cash with both hands and make a stash. New car, caviar, four-star daydream. Think I'll buy me a football team.
Welcome back. If this is your first visit here, well, I do appeals in Illinois, and I also do commentaries on appeals. And that's about it for the introduction, so let's get right into it. Today's case involves two well-known appellate lawyers. Mom is employed by Michael D. Domenico, and Dad was represented by Myra Fortes. Now, neither lawyer had a heads up that I was going to feature them, so it kind of goes without saying that the following is just my take on the case. Their mileage and yours may vary. And this case is about Dad's efforts to get his old child support order modified under today's more progressive formula. If you're new to family law, this quick but unfortunately very poorly put together animation should hopefully set the stage for why this has been such a thorny problem as of late.
In Illinois, child support can be modified when the moving party establishes a substantial change in circumstances. However, in 2017, the ISBA amended Section 505 to a comparative income system. Previously, only the non-custodial parent's income was factored into the decision. Now, the incomes of both parents are considered. For working-class parents, very little changed under the new law. But high net worth parents noticed a significant variance between obligations set under the old law versus the new. To prevent a flood of litigation, the ISBA also amended Section 510 to prohibit parents from seeking a modification of support based solely off of the new changes in the law. Instead, they must show that new substantial events have transpired that warrant a recalculation of child support. But new arguments have also arisen that the ISBA did not contemplate. One, which is the focus of today's case, is whether the parties contemplated the very event that the non-custodial parent is now arguing as the basis for their child support reduction.
And the problem in today's case actually dates back to two previous cases, Salvatore and Connelly. I covered both on my channel, but only Connelly survived when I updated the page back in the fall of 2019. And that video is a little rough to watch. I was still figuring out how to use the camera, and it was clearly shot before I started working out at the gym. My neck won't even fit into the shirt anymore. Anyways, I've included a link to that video in the description if you really want to watch it, but with all that said, let's get down to brass tacks. The thorny issue is contemplation. The appellate courts, well, they've thrown down the gauntlet at the ISBA's feet numerous times, stating point blank to the Bar Association, hey, you did nothing to change Section 510 except to say that the new law can't be used by itself as a basis to modify child support. Quick aside, some of you will say, David, the ISBA doesn't vote these bills in, the legislature does, and that's a fair point. But last year, well, we put this on the cover of our monthly magazine. The reason why is that, in my opinion, family law has gotten so complicated. Every section is kind of daisy-chained to another, sometimes with a dead man switch. The legislator is become very dependent on the ISBA for guidance, almost to the point where sometimes we're drafting the very laws for them. So if someone knows of a bill that was authored by the ISBA that the legislator shot down within the last 10 years, let me know in the comments and I'll issue a mea culpa on my next broadcast. Again, this is just my perspective. That said, let's return to contemplation and modification of child support. Now, it's been long held you can't modify parenting agreements based on contemplated events. Prior to 2017, you'd see this almost exclusively applied to custody or visitation issues, which kind of makes sense. If you agreed to a schedule based on your current work hours, but everyone knew, including yourself, that you were starting a new night shift, let's say 2 weeks later, that was clearly contemplated, and it's kind of unfair to make everyone have to relitigate the issue when it could have and should have been addressed at the time of settlement. Or otherwise stated, the defense of contemplation is to prevent people from wasting court time and money relitigating issues that should have been handled the first go-around. But like that 80s horror film you can't get out of your head, along comes In Remarriage of Salvatore. What makes Salvatore so controversial is that, the contemplated fact that sort of killed the case had nothing to do with child support. It was boilerplate JPA language, namely a provision for mom to update her contact and work info, along with kind of a passing reference to employment when it came to health insurance. Now, it should be noted, in that case, dad was employed, mom wasn't at the time of divorce. Again, This proviso was merely boilerplate language. It was inserted well before the ISBA announced they were even changing the law. At the time the JPA was put together, no one knew the law was going to change. But, and there's always a but, since no other amendments were placed into Section 510A, the appellate court finds that this statement was evidence that Dad knew Mom, who again was unemployed at the time of the divorce, was going to eventually find a job. So when Dad later filed a motion saying, hey, Mom's now employed, she should chip in a little bit, both the trial and appellate court denied it. The fact that no one knew the law was going to change is really immaterial, although observers will point out that had the parties known, chances are they probably would have worded the settlement very, very differently. I'm going to come back to Salvatore a little bit later in the video, but the other recent case contemplating modifications is Connelly. Connelly isn't as controversial, but it's still worthy of mention. Prior to 2017, when Dad's income had some volatility to it, we would often use a true-up mechanism. For example, if you worked a salary but also got a commission on the side, well, you'd set 20%, let's say, for the salary, that's your baseline, and each quarter, year, or whatever, he'd just true up, if any, 20% from his commissions. Seems pretty simple, right? Well, again, because the ISBA didn't change anything in Section 510, that true-up is now evidence that the parties contemplated Dad's income would increase and continue to increase, and it was one of the reasons in Connelly that Dad's motion to modify was denied. Which brings us to today's case, Durdov. Now, normally the standard review in a child support case is called abuse of discretion. Think of the standard review as a metric on how big of an error needs to be made before the appellate court's going to intervene. Abuse of discretion is the highest. It's really not that the judge got it wrong, but likely no other judge in any of Illinois' 102 counties would have reached that particular ruling. However, when the issue raised on appeal involves the legal effect of a set of undisputed facts, the applicable standard review is de novo, and that's the lowest, meaning really the side with the better argument wins. In today's case, at the time of divorce, Mom was working part-time, Dad full-time. She later gets a better job, Dad files for a decrease stating, hey, she can chip in more, etc. And no surprise, Mom argues, hey, our judgment has virtually the same boilerplate language as in the Salvatore case, so you should just deny this, Judge. And the appellate court does, but not because of that boilerplate language. They note that since Mom was employed a bit part-time, the proviso requiring the reporting of employment contact information and health insurance didn't trigger a Salvatore outcome. What triggered Salvatore in this case was when Dad and Mom settled a separate issue, the issue of maintenance, where Mom agreed to have her income imputed for purposes of setting her alimony. The appellate court notes the imputation was limited to maintenance, but they feel that's clear evidence that there was some discussion that the parties contemplated Mom would eventually make more money. Before I list the bullet points from today's case, I want to re-ask a question I posed during my, now deleted video on Salvatore, namely, would we expect the same treatment if the roles were switched? For example, if it was Dad who was unemployed at the divorce, later gets a job, does anyone believe that Mom's motion to increase support would be denied because of that proviso in the JPA? Or even here in Durdov, where if Dad was part-time then gets a full-time job, does anyone believe a maintenance imputation proviso would stop Mom from getting an increase in support? And maybe that's just a commentary that's well-deserved for another time. But be that as it may, here are the takeaways based on recent case law. First, although there's no bright line rule, generally most modifications require either the non-custodial parent's income or the child's needs, or both, to have changed. Second, true-ups are now bad news. Third, usually a 10% shift in income or more is required before we can recalculate support. Fourth, if the custodial parent's income has increased, even by a lot, you still have to examine it in light of the other parent's income before resetting support. Fifth, if the incomes of both have increased, it needs to be a lot. And lastly, watch every word you put in that settlement. Case law takes no prisoners when it comes to contemplation. Anyways, that's all I have. Thanks for watching. And if you stay for the credits, you'll see a few cases that also discuss Salvatore or Connelly or contemplation of future events as it relates to modifications of child support.
Gone are my blues and gone are my tears. I've got good news to shout in your ears. The long-lost dollar has come back to the fold. With silver you can turn your dreams to gold. Oh, we're in the money, we're in the money. We've got a lot of of what it takes to get along. We're in the money, the sky is sunny. Oh man, depression, you are through, you done us wrong. Oh, we never see headline about red line today. And when we see the landlord, we can look that guy right in the eye. Oh, we're in the money, come on, my honey.